Let's get ready to rumble!
Mga korap, pinaka-the worst na korupsyon sa Pilipinas. Mga putang ina ninyo, mga hayop kayo, mga kriminal din kayo, mga politika.
Bakit ako tumakbo? Galit ako sa gobyerno. Korupsyon, drug. Nilagyan ko ng 3 to 6 months. Sinabi ko gawin ko yan. Maasahan niyo. I will do it. Even if makaposta ko, even if I lose my life, my honor, and even the presidency.
We find corruption everywhere in government. Let me ask you, when will corruption end? Kailan ba talaga ito, hanggang kailan?
Ako, nangangarap ako ng isang mapayapang bansa, may pagkakaisang bansa, maunlad na bansa, higit sa lahat. Bansa na may Panginoon, bansa na lahat ng tao sumusunod sa ating gobyerno, bansa na ang lahat ng tao nirerespeto ang gobyerno, at ang gobyerno natin hindi tinutolerate yung korupsyon. Ang gobyerno natin ini-implement ng gusto ang batas natin, mahirap man o mayaman. Yan po ang gusto kong na isang leader na maging mamuno sa ating bansa, na may malasakit, pagmamahal na tunay para sa ating mga kababayan.
1. 18th Congress of the Republic of the Philippines, Second Regular Session. Senate. SB. No. An act adopting the jury system in criminal trial courts. Explanatory note. The jury system is basically a procedural device that shall implement the administration of the Philippine criminal justice, pursuant to Article 2, Section 1 of the Constitution, which states that the Philippines is a democratic and republican state. Sovereignty resides in the people, and all government authority emanates from them. The last sentence of this provision is being emphasized to give meaning of the importance of the authorization of the sovereign people in the government they have created in the Constitution, which said sovereignty resides in the people, and all government authority emanates from them, meaning from the people, without exception. Why is the adoption of the jury system very imperative? Because Philippine democracy is fast collapsing, and it is the means to enforce the rule of law, instead of the law of force, in our democratic form of government. It is the means for the people to 2. Vote justice to prevent abuse in politics. It prevents the people from joining violent rebels in the enforcement of our laws. Adoption of the jury system is the solution, not only against government graft and corruption, but also against the ongoing pockets of people rebellion until today, since the time we first established the Republic of the Philippines by President Emilio Aguinaldo. My team and I on the subject have consulted our criminal rules of court, Rule 110, and it seems that this implementing rule, in my own layman's understanding, that we have been fictitiously using the name of the people, more precisely the people of the Philippines, as the seat of sovereignty of the people in Rule 110. To me, personally, this is a bothersome concept, although I am not a lawyer, for the following reasons. 1. The word sovereignty can only be vested in real people who can think and vote, who can feel the pain of government graft and corruption, and have suffered the pains of poverty and rebellion. 2. The word sovereignty cannot be vested in the name of the people because it is just a fictitious, if not, a dead creature, and it is more of a government self-serving rule. We did not create a government to serve the government. We, the people, created the government to serve us, the real people, to keep us alive, prosperous and happy. The name the people of the Philippines cannot think and cannot vote, and I believe that the framers of our Constitution have not intended to vest the people's sovereignty on people who are already living 6 feet below. It is funny, but it is true, because of Rule 110 in our criminal rules of court. 3. Some people have argued that the jury system has not been authorized, or even mentioned, in the Constitution, and therefore it would be unconstitutional to install the system in the Philippines. However, it may be noted that the Philippine Constitution has neither expressly nor presumptively forbidden the creation of the jury system. Its creation is implied because our Constitution is a democratic constitution where the government is ruled by the people, for the people, and of the people. It is commonly used in making a country progressive, successful, and powerful, and wherein we can live with great comfort and peace with our government like the USA, Australia, Canada, and the UK. Adaptation of the jury system in justice has long been overdue ever since the Constitution has been ratified by the people, in which they have created the independent Department of Justice and the Ombudsman. As a procedural device in aid in their functions, the jury systems, like the electoral system, are the essential means of the people to deliver their votes to authorize the government to prosecute and to condemn for punishment of capital crime offenders of society. As of today, these independent departments have been functioning, unfortunately, without authorization by the people. As a result, the Justice Department and the Ombudsman have been operating de facto with no choice under the supervision of the Executive Department, because their department heads have been appointed by the President, and our criminal justice systems have become the hideout of the powerful and untouchables of Philippine society. Instead, the criminal justice system in the country has been functioning with self-serving government prosecutors and self-serving government presiding trial judges, wherein the lamenting voice of the sovereign people for justice have been illegally ignored. Enactment of the use of the jury system shall put an end to these self-serving government injustice rules wherein only the rich and powerful can buy justice. The Department of Justice and the Ombudsman are supposed to be the proclaimers of the people's voice in justice, and until today, they are not. Our criminal justice system condescendingly looks down upon the people like illegal aliens in our halls of justice. Our government has not realized that by depriving the people of their will in justice, it is in fact the very real and ultimate cause why many people in our country have been joining government rebels and have resulted in social chaos in many parts of our country. It is only by embracing the use of the jury system that will bring them back in the mainstream of the Philippine society so that they can peacefully partake in our criminal justice system. Instead of bullets, they will use ballots to preserve our democracy. In our democracy, the sovereign people are the backbone of justice, which the government should not, and could not, actually ignore. By the neglect, if not ignorance, of our government of not allowing the people to decide in justice, since the creation, and subsequent amendments, and approvals of our current Constitution, it is in fact the basic invisible fundamental cause of the chronic graft and corruption of the Republic of the Philippines. Unless the jury system is adopted in our criminal trial courts, this republic will eventually collapse, and we will no longer be sitting here anymore in comfort in our Senate chamber sooner than later, as shown by the increasing discontent of the growing anti-graft population of, and the unhappiness of the President, over the government graft and corruption in this country. This act is consistent with the desire of the President that every person of legal 5. age, man or woman and those in between, regardless of occupation, whether employed or not in the government, to become as a secret reporter to the Ombudsman of any person who is engaged, or is engaging, in the act of government corruption, and the reporter shall be protected from being removed or demoted in his or her job, if any, in the government or in the private business sector of our society, and he or she instead shall be compensated for doing so. This proposed law contemplates the formation of two types of jury: the grand jury and the trial jury. The analogy between these two juries are similar, and are very easy to understand as follows to avoid the rise of rampant lawlessness. First, before the prosecutor can pursue the crime suspect in court, he shall gather a group of 23 sovereign, not government-controlled, people by lottery from among the residents of his locality. This group is called the grand jury. The prosecutor shall then secretly present to this grand jury his prima facie evidence of the alleged crime, without the presence of the felony suspect, who is still free in committing his crime. Thereafter, the prosecutor shall then instruct the members of the grand jury to convene independently and secretly, without his presence, or anyone else, to discuss the merits of his evidence within a short period of about 45 minutes. Thereupon, after the lapse of 45 minutes, and without taking a prior survey votes, the secretary of the prosecutor shall knock at their door and provides the jurors with grand jury ballots with the instruction to fill in secretly with their votes without further discussion within the next 15 minutes. The secretary shall then leave or exit the grand jury room to allow the jurors to write their votes independently and secretly. After the lapse of 15 minutes, the secretary comes back in again to count their votes. If there are at least 12 yes votes to accuse the crime suspect, then a criminal complaint is thereby 6. Written, signed with initials by those who voted yes, and the complaint is then filed in court. The grand jury, or its members, shall not be required to issue a written explanation or justification of their decision of accusing the suspected felony offender. This is in consonance with the principle that when the master decides, he has no obligation to explain his decision to his servants. The filing in court of the GJ indictment shall become the authorization by the people to the government to prosecute the crime suspect in compliance with Article 2, Section 1 of the Constitution, which says sovereignty resides in the people, and all government authority emanates from them. In plain words, all authority of the government comes directly from the people, and not in the name of the people. It may be noted that there is nothing in the Constitution that requires presence of the crime suspect in criminal investigation proceeding like the way the National Bureau of Investigation is doing. It only requires that the crime suspect shall be notified to remind him of his right to be informed, of his right to remain silent, and of his right to consult a lawyer of his own choice, which is complied with in writing in this proposed law. Grand jury investigation hearing is strictly confidential, as an antidote against the commission of crimes that are always carried out with covert secrecy. Second, the presiding judge of the trial court, upon receipt of the filing of the grand jury indictment, when the accused is already arrested, and he is set for trial in court, the court presiding judge shall then gather a group of 12 people by lottery from the residents of his locality. This group is called the trial jury, which shall hear and try his case. Its members are different from the people who composed the grand jury. 7. As expressly required in the Bill of Rights in the Constitution, the accused is entitled to be present in court with the assistance of his own counsel during the trial proceedings to meet and confront the witnesses against him. Just like the way it is done in the grand jury proceedings, at the end of the presentation of the evidence at the hearing and trial, the members of the trial jury are required to convene in a secret and private jury room to discuss, deliberate, and decide the case with their votes without the presence or control by the presiding judge. The verdict of the trial jury is the authorization of the people to the presiding trial judge to proclaim the guilt or innocence of the accused. If the decision of the trial jury is a guilty verdict, it is then the authorization by the people to the presiding judge to impose the prescribed penalty by the law upon the convicted accused crime offender. Adoption of the jury system shall emancipate the prosecutors and trial presiding judges from their presidential appointment status, because they will be basing their decisions and judgment upon the sovereign jury decision of the people, which cannot be overruled by any powerful public servant. The jury system shall transform the Justice Department and Ombudsman into a true, independent, and co-equal in prestige and dignity with any and all independent government branches or departments, who shall all, henceforth, yield to the supremacy of the deciding power and authority of the people through the jury system, and to no other government high official. 8. Instituting these two jury systems shall solve the following chronic problems in our society, namely: 1. Government graft and corruption, and 2. People rebellion against our government. Amplification of this explanatory note. The attention of the reader of this explanatory note is invited to peruse the attached 2 comparative diagrams in the next page below to understand on how each of the various government departments shall acquire their respective independent, direct, and separate empowerment from the people as their source of authority in Article 2, Section 1 of the Constitution. 9. Diagram pages. People's power diagram and authorization of the sovereign. people to their independent and separate government branches. Sovereignty resides in the people, and all government authority emanates from them. Article 2, Section 1 of the Philippine Constitution. Diagram 1. This is an illustration of the desired and proper set up of empowerment of the independent government. Departments as authorized by the sovereign people. Diagram 2. It illustrates the current deficient government empowerment setup. The sovereign people of the Philippines, from whom authority of each government departments below comes from directly, separately, and independently, Art 2, Sector 1, PH Constitution. Ombudsman with Grand Jury, Executive Department, the President, Legislative Department, the Congress, Justice Department, the Judiciary. Judicial Division of the Department of Justice with Trial Jury. Prosecutorial Division of the Department of Justice with Grand Jury. The sovereign people of the Philippines, from whom authority of each government departments below comes from directly, separately, and independently, Art 2, Sector 1, PH Constitution. Justice Department, the Judiciary. No authority. Ombudsman, no Grand Jury, no authority. Executive Department, the President authorized. Legislative Department, the Congress authorized. Prosecutorial Division of the Department of Justice. No Grand Jury. Judicial Division of the Department of Justice. No Trial Jury. 10. Diagram notations. In Diagram 1, along with its connecting vertical and horizontal terminal lines, it illustrates the perfect flow of authorization from and by the people independently, separately, equally, and directly to and upon each of the different government departments, which is expressed and accomplished at all times by the secret votes of the people in the form of their electoral votes for the executive and legislative departments, and by their jury votes for their authorization in the criminal justice system with respect to the functions of the prosecutors and presiding judges. It complies with Article 2, Section 1 of the PH Constitution, which says that sovereignty resides in the people and all government authority emanates from them. In Diagram 2, the unconnected departments with the people, namely the Justice Department and the Ombudsman, signify that they have no means to reach the sovereign people to vote to authorize their acts in administering the criminal justice system. The Justice Department and the Ombudsman have alienated their departments from the ambit of protection of the sovereign people with whom they are constitutionally required to obtain the empowerment for their prosecutors and presiding judges to act pursuant to Article 2, Section 1 of the Constitution. This act, the proposed adaptation of the jury system, shall become the means of the prosecutors and judges of obtaining their authority directly from the people in performing their functions in the criminal justice system. This act shall nullify Rule 110 of the Criminal Rules of Court, which created the criminal justice as a government self-serving monopoly for being in violation of Article 2, Section 1 of the Constitution. This act shall further put an end to the conflict of interest of the Justice Department, while it supervises both the Prosecution Division and the Judicial Division wherein the government acts as an accuser of a felony crime suspect, and at the same 11. Time as protector of his inalienable Bill of Rights in Article 3, Section 1 of the Constitution, which says no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws, and which shall require full and prior compliance of Article 2, Section 1 of the Constitution, earlier quoted above. The role of the jury trial presiding judge. The presiding judge during the trial enforces the rules of the court, including observance of court discipline for the orderly conduct of the proceedings. He issues the instruction on the law of the case, among others. He rules in the admissibility of evidence, which is no different in ruling in a solo judge trial. If it happens that the presiding judge has committed an error in the instruction on the law, then of course, it should not be blamed on the jurors. If the accused is aggrieved for such error, his lawyer can appeal, and should not blame the jurors either. The role of the jurors. The role of the jury or the jurors is simple: sit on their chairs and keep silent. Do not talk. Just simply listen to the instruction and the presentation of the evidence. If a juror thinks that something is wrong in the presentation of the evidence by a trial lawyer, it is not the juror's fault. He should not talk. Should he violate this rule, his comment may cause a suspicion of partiality on any party to a case and becomes a cause for a declaration of a mistrial. Just simply listen and keep quiet. Do not ask a question. Again, just shut up. The juror should not show that he is an advocate for any party to the case at hand. His obligation is, again, don't talk. Listen only to the instruction and in the presentation of the evidence. No juror is penalized for not making any question on any issue he does not understand. If the lawyer of any party at the trial is unprepared and cannot make his evidence understood by the jury, that is not the fault of the juror. 12. The only time a juror is allowed to talk is when he and his fellow jurors are instructed to deliberate privately in the private jury room. The only obligation that a juror has to comply with is to vote, one way or the other, according to what he learned at the trial and his recollection of the evidence during their private discussion. He cannot be neutral, or else he can be held in contempt of court for not making up his mind. He must vote. Jury trial verdict by majority rule. The verdict of the jury shall be by majority rule instead of the unanimous rule. A tie vote of 6 guilty and 6 not guilty shall be acquittal for the accused. In the majority guilty rule, the penalty imposition shall be graduated. The higher number of the majority guilty verdict shall draw a higher penalty if the accused is convicted, and it will be handed down upon reading of the verdict. No waiting time to compute is required. Once found guilty, the convicted offender will be promptly informed while his verdict is being read in open court, in a way it is a speedy delivery of justice as constitutionally required. Criminal penalties are usually divided by law into 3 scales, namely, minimum, medium, and maximum. In the majority rule verdict, the ranges of penalties of imprisonment are the following. A. 7 to 8 majority guilty votes shall draw a minimum penalty of imprisonment. B. 9 to 10 majority guilty votes shall draw a medium penalty of imprisonment. C. 11 to 12 majority guilty votes shall draw a maximum penalty of imprisonment. If the law provides no scale of penalty such as, example, 12 years of imprisonment, this whole period shall be divided into 3 as follows: 1 to 4 years equals 13. Minimum, 4 to 8 years equals medium, and 9 to 12 years equals maximum, and from there, the number of votes shall then be factored to find the imprisonment period of the convicted crime offender. There is a lesser burden on the trial presiding judge in calculating the penalty for imposition on the accused in the majority rule verdict. The fines shall likewise be graduated correspondingly in the same fashion. In the unanimous rule verdict, the burden of reaching a verdict is very profound to the point where some jurors sometimes go to the extent of almost physically forcing a fellow juror to vote with the majority, although, in conscience, he/she cannot convict the accused and comes out with a heavy burden in his/her heart and torment. If he/she does not give in to the pressure, the jury trial end up as a mistrial, called the hang jury, that will require another trial which becomes more expensive, harder to prove, and some witnesses may no longer be available in the trial. Finally, the winner usually are the rich and the powerful crime offender, which is no justice at all. This cannot happen in a majority jury trial verdict. Appeal from a jury verdict. The accused who is aggrieved of a jury verdict in finding him guilty, with the assistance of his counsel, may appeal on the verdict against him only on an error of law, but not on an error of facts. Finding of facts by the jury is always final. Reason: finding of facts includes the observation by the jury on the demeanor or body language of witnesses, lips or eye movements that elicit truth or falsity during the testimony of the witness and cannot be recorded by the court reporter, stenographer. When an appeal is filed, the appellate justices have no way to speculate about the demeanor of witnesses that cannot be read in the records of the case. 14. Prescribed action forms. For easier understanding of the provisions of this proposed law, please take note of the following table of forms. They are called action forms to conveniently and uniformly implement the operation of the jury system around the country. Table of Forms. Form hashtag description GJ0 Office Staff Registry to obtain the secret ID hashtag of each office personnel. GJ1 Newspaper Advertisement inviting grand jury membership applicants. GJ2 Newspaper ad of the application form for grand jury membership. GJ3 Registry for grand jury service applicants, print in landscape form. GJ4 Notice letter to the applicant for grand jury service. GJ5 Oath of secrecy by the grand jury members. GJ6 Grand jury ballots and memorandum of grand jury proceeding. GJ7 Notice of grand jury investigation to the crime suspect. GJ8 Payroll for the grand jury members. GJ9 Instruction to the grand jury and grand jury proceedings. GJ10 Advertisement for whistleblowers to secretly report a crime or anomaly to the GJ11 Registry of Public Complaints, print in landscape form. GJ12 Registry of Cases for Action, print in landscape form. GJ13 Grand Jury Indictment Form Criminal Accusation Form. GJ14 Grand Jury Unit, GJU, Formation Team Registry, print in landscape form. GJ15 New Grand Jury Unit Registry, print in landscape form. 15. GJ16 Grand Jury Voucher Grand Jurors Pay. GJ17 GJ Ballot Logbook Registry of Jury Votes. GJ18 GJ No Indictment Form or No Bill. GJ19 Witness and Exhibit List for attachment to the office file of Form. GJ13 GJ20 Hold Departure Notice to the Secretary of Foreign Affairs Passport Revocation. GJ21 Notice to the Bank of the Accused. GJ22 Notice to the Registrar of Deeds. GJ23 Grand Jury Sign-Off and Disbanding Record. GJ24 Subpoena and Summons of the Grand Jury. GJ25 Subpoena and Summons Registry, print in landscape form. GJ26 Whistleblowers Internet Form to secretly report graft and corruption, etc. GJ27 Bill of Expenses for the creation and operation of the grand jury system. GJ28 Witness Pay Voucher, as many as there are witnesses listed for a case. May I repeat that Philippine democracy is collapsing and almost in TKO. I know and I could feel it. I was there one time, and prompt approval of this bill is very urgent if we still want to have it when we wake up tomorrow. Emmanuel D. Pacquiao, Senator.
Juror ka, juror siya, juror ako, juror tayo. Palakasan na hindi uso sa bayan ko.